Would you agree that there is a distinction between accepting an office that is meant for and even reserved for former judges, like all the examples you cited, and accepting, say, a Rajya Sabha seat or a governorship, which are not only for judges? And some of the judges who've done that, they have been particularly
no. We've had some exceptional individuals who've occupied those offices as well. People who have done remarkably well in those offices. In fact, I believe to the contrary, that there's a great deal of experience which judges can bring to, say, the legislative bodies. I think I appeared before the Joint Parliamentary Committee just 2 weeks ago on the One Nation, One Election constitutional amendment which is proposed. I was requested by the chairperson to make my presentation. I said, well, this is the first time in my life I'm going to be doing that. But I felt that I learned such a great deal from interacting with our parliamentarians, and realized that, across party lines, the work which is done in parliamentary committees is such a high constitutional order, where people have forgotten to that moment, the party divisions. They are talking about pure constitutional doctrine. Likewise, I believe that there is an inadequate sense of understanding about the true nature of the judicial function, the challenges which face our judiciary. And therefore, these watertight divisions between the legislature, the executive, and the judiciary, which must hold so long as you are in office, are not as watertight, or shouldn't be as watertight. They're not as watertight in other parts of the world. We know that they are not as watertight in the United States. I'm not sure whether that's a better system or not. It's ultimately a matter of individual conscience as well. But I, for one, feel that we shouldn't be laying down absolute boundaries, because the absolute boundaries which we tend to lay down are not valid in constitutional theory, and they don't make good for good constitutional practice as well. I mean, coming back to the Constitution, it's such a visionary document. Why did the founding parents, the fathers and mothers, the 15 members of the Constituent Assembly who are women, as you referred to in the book, why is it that they didn't pose a disqualification on former judges entering into legislative office? And that was for a reason. They imposed other disqualifications, but not this one. So I don't believe in drawing absolute or rigid boundaries. I think life is much more fluid, and we should allow it to remain that way.
And with people like yourself who are at the helm safeguarding this pillar of democracy, I think we are good. But moving on to my next question, which I think our Gen Z and millennial audience are very passionate about: freedom of speech and expression. Your Lordship, Article 19(1)(a) guarantees free speech with reasonable restrictions. Yet, time and again, we've seen comedians are jailed before performing, creators face FIRs for satire. And this happens while elected leaders make inappropriate remarks, be it communal or otherwise. They are let go without consequence. How does the judiciary address what many feel is an uneven application of free speech? Do you think sometimes those in power seem to be protected and those dissenting are penalized?
Well, I, for one, believe that, free speech is at the core of constitutional liberty. And the ability of people to speak, to dissent, to express a voice which is away from the mainstream, as also within the mainstream, is at the core of the functioning of a democratic polity. The ultimate protector of free speech is not just the judiciary or the law, it's also civil society. But the judiciary and the rule of law have a vital element, are a vital element in the protection of free speech. What is of concern to me today is the unwillingness of our trial judiciary, particularly, to be liberal in the grant of bail in matters particularly concerning free speech. A person, even a day's incarceration as an under trial, if it's wrong, is a day too long. Even an hour is an hour too long, because it has a chilling effect on what others perceive can happen to them if they speak something which was, frowned upon by speaking truth to power. Therefore, particularly because the trial courts have the first interface with our citizens, it's the trial courts which have to be strengthened in their ability to grant bail. What is now happening is this, that matters which should end in the trial court granting bail move to the high courts. Matters which should end with the high court granting bail move to the Supreme Court. As a result of which, there's a real danger that the system is becoming dysfunctional. Because by the time a case reaches the Supreme Court, several weeks or maybe several months have passed away. And then what happens if the Supreme Court grants bail in a case where the trial court should have granted bail in the first case? And therefore, the presumption that, bail should be the rule and jail should be the exception, particularly in matters involving, core political rights like free speech, must necessarily govern. But we live, unfortunately, today in a culture of distrust about public institutions. And I dare say that judges, particularly at the trial level, are sometimes fearful of whether the grant of bail would be misunderstood as being motivated by some improper consideration. We have to protect our judges. Even if a judge was wrong in the grant of bail, that judge should be protected. There's obviously a remedy, a higher remedy. You may set aside an order which is wrong. But then to, castigate a judge or bring a sort of a moral disincentive to a judge who's granting bail is unfortunate. And that's what has happened. But there's a general culture of distrust of all public institutions. And this is part of the reason for where we find that we are today. But this is certainly a matter of concern.
Dr. Tharoor, I'd like to ask you the other side of it. You've engaged with a lot of young people at IMN as well. We engage with impressionable young minds, which are usually below 19. This is an exception audience today, which we're very happy to organize as well. But these young people consume vast amounts of content online. Do you think that the government should protect them from harmful, polarizing, and inappropriate content, or do you think it should be left at individual discretion?
Well, I think the problem with asking the government to control what people can consume by way of information is that the government may have an agenda different from what you intend when you propose such a thing. So I'd prefer to keep the government's hands off any kind of information flow. The question of then who should control or whether it should be controlled at all, I think is up to the individual and the individual's family. I mean, there are families where, children's time on the net is rationed, where they're told they can only go on the internet for an hour a day or whatever it may be. There are others where some are not allowed to have a mobile phone or access to one until they reach a certain age. So there are various ways in which this could be regulated short of getting the government involved. I'm actually a bit nervous about getting governments involved. Governments have political agendas, any government, and governments obviously have points of view, which means that in the guise of restricting something that's harmful, they can also restrict things they don't like. And then whose morality comes into play? It's a politician's, not that of any civil society standard or family standard or even judicial standard. So I'd rather keep the government out of this business. It's not easy. I mean, I know that many people feel that complete lack of regulation can be dangerous. But I think that if you give regulation to the wrong people, that can be more dangerous.